Good evening. Captain Retired Matt Edwards here with the next installment of the Observation Post Facebook Live Weekly Update, Thursday, the 11th of April, 2024. Now, what I plan to do is go through a couple of items on my numbered list and then get into a couple of things. I think I'll talk about a TOF class action that finished in 2019. I haven't looked at it in the past because I knew it was going to trigger me. So I looked at it the other day, and sure enough, there are things in there that bugged the hell out of me. And I'm also going to be talking about taxes again. No great surprise there. I spent 16 years as a Canada Revenue Agency tax collector. Although on paper I was a teacher, but I worked as a tax collector. Anyway, number 481. Outline what I want, as simply as possible. Now see, this relates back to a lot of people get confused about all the stuff I publish, post, put out. And when I was talking to Manulife years ago, I had them so exasperated, they said, "What do you want?" And I said, "I want you to follow the law." Now to me, that's simple. For example, the Canada Pension Plan Act, Section 65(1) says that no one can touch the Canada Pension Plan. But these assholes got me to apply for the Canada Pension Plan, and then they took it into account. Now, they took it into account not once, not twice, not 3 times, but 4 times. I lost the Canada Pension Plan off my Sun Life insurance, off my Manulife insurance, and my public service pension, and my Canadian Forces pension. Now, you can't tell me that this is justified in a common law democracy. You are not supposed to harm the disabled. And I'll get into that as well later. Now, number 482, review some success stories. Well, even though we haven't had a systemic fix for all the different things that I've been working on, I'm trying to remember, Master Warrant Officer retired Dan Mansell. He had his Canada Pension Plan disability being taken into account at 2 or 3 different places, like I've been talking about. And he had a refund from Veterans Affairs because they realized they couldn't do it. Sergeant retired Gerard Parsons. He got a check, I believe, for $60,000 from Great West Life from a private insurance because they realized they couldn't take it into account at the same time as Canadian Forces pension was deducting it with bridging. So that's proof that bridging and insurances operate the same way. They're both clawbacks that are caused by the Canada Pension Plan. Okay, number 483. When and how did Canada enact Canada Pension Plan Act Section 65(3)? Now, this is something I always talk about. So the government put into law, according to the Hansard, in 1991, they put a section in there that allowed a disability income program to get a retroactive payment from Canada Pension Plan Disability directly. Now, I was talking to a Canada Revenue Agency person about my taxes being unfiled, and I mentioned to them, that person, about, all of these governments and insurances want to be subsidized by the Canada Pension Plan Disability. They want to offload their cost to another program so that they will profit. And I told them that that's against the common law on pensions, because you are not allowed to divert a pension, because the pension is meant to be exclusively for the pensioner. So in order to do that, you have to sign an irrevocable consent form. Now that's to assign the benefit to somebody else. Now the government shouldn't be allowing this because it's against the common law and it's against public policy, but they do allow it. Now, I was recently thinking about the Dennis Manew's class action. The Department of Justice lawyer said, Mr. Manews has accused us of assigning the Pension Act when he gets the entire amount. So, we didn't assign, he didn't assign his pension to us. But you see, there's a couple of holes in that argument. if you think about the Canada Pension Plan Disability instead of the Pension Act, they do a direct interception. Instead of taking the money into account, they take the money directly when it's diverted by the federal government Canada Pension Plan. Now, as I explained to the guy yesterday, you're supposed to receive and enjoy money in order to be taxed. The money goes directly to Manulife, then you cannot tax it in the hands of the disabled person because they didn't receive the money. This is going to blow up in their faces one of these days, and I'm trying my best to light the fuse. Now, with that, I'll close my document that I'm working on with the number list, and I'll discuss the TOTH class action a little bit, and then I'll talk about taxes again. Now, the TOTH class action was, as far as I know, it started as the equivalent to the Manouche Federal Court 2012 case. And the earnings loss benefit deducted the value of the Pension Act pension in the same manner that the Department of National Defense took the Pension Act pension into account to save the payer money. There are some major differences, though, when you think about them. SISIP is a contract of insurance, allegedly. So they put into the contract a provision, Section 24A, that says they're going to deduct, clawback, offset, set off, other relevant income. Now, under the Veterans Wellbeing Act regulations, which the government brought in for the earnings loss benefit clawbacks, they basically copied the exact same things that SISIP claws back, but they do it in statutory law via regulations, which are subordinate law passed under the major law, the Act. So basically, one is done in private contract law, one is done in public statutory law. But they did the same thing. And the Canada Gazette in 2006 said that they were designing the new Veterans Charter. The earnings loss benefit was meant to mirror SISIP, and it was supposed to top up SISIP. Now, that begs the question, several questions. Didn't anybody think about the conflict of interest? Because with the Department of National Defense taking the Pension Act pension, it was two different departments. Veterans Affairs Canada pays the pension, and the Department of National Defense pays SISIP. Now, when Veterans Affairs Canada was taking into account the Pension Act pension, it was Veterans Affairs taking into account a Veterans Affairs payment, which creates a serious, insurmountable conflict of interest. What I mean by that is that, Pension Act Section 30 prohibits any creditor from taking the money into account or taking the money directly. So, Veterans Affairs should have told the Department of National Defense, listen, I know you put it into the contract in Section 24A of the policy, but we have a law that's passed by our elected members of Parliament, Section 30 of the Pension Act. So because this is our payment meant to compensate the disabled veteran for his injury in military service, it's meant to be a replacement for a lawsuit in tort. It's equivalent to personal injury damages. So it is not acceptable in law for you to take this into account. So stop it immediately. Instead of doing that, they turned a blind eye to it and allowed it to continue and to happen for 36 years. Now, in the TOTH class action, the Manouche class action went and paid retroactive to, depending on the number of people, first it was 4,300 or so veterans, and then it was up to 10,000, and then it was up to 14,000 veterans were supposed to receive some form of refund. But they went back, in theory, to 1976, which was when the Pension Act pension was first clawed back. Now, some people might think this is generous, but in the law, you have to give a remedy to the person that you injured for the injury you caused. So going back to 1976 wasn't a gimme. It was just how justice works. But in the case of the earnings loss benefit, the government decided that it was only going to go back 3 months. They went back to the 29th of May 2012. Now that happens to be the date of the Manouche case. So therefore you can't tell me that it's not linked to the Pension Act pension clawback. But yet, when I'm reading this case, it talks about there's going to be a payment to the veterans in the amount of $100 million for the breach of their human fucking rights. Told you it was going to trigger me. There was no breach of human rights, really. There was a breach of statutory fucking law in Section 30 of the Pension Act and Section 67 of the Financial Administration Act that caused monetary damages in that the disabled veteran did not get their payment that was authorized under the Act. That was really what happened. Now, for some reason, and I think the government tries to divert and confuse people, and I think many of the veterans that might have been part of the Toth class action would have also been part of the Manouche class action. And I think in the government's mind that if you receive damages under the Manouche case, then you are not entitled to damages under the Toth class action. That's what I suspect they were thinking. Now, bolstering my idea is leading seaman retired Sean Kareen, who wasn't included in the Toth class action despite my efforts to try to get him into the class. He was having his Pension Act pension clawed back from his earnings loss benefit along with his Canadian Forces pension to reduce his earnings loss benefit to 0. Now, at the same time, the Department of National Defense was taking into account his Pension Act pension and presumably his Canadian Forces pension and later his Canada Pension Plan Disability to reduce his payment to not very much. Now, the thing is this is where I discovered that thing I call the double dip clawback, which I then added to that to call the triple dip clawback. Now, the double dip clawback is when, for example, the Canadian Forces Superannuation Act pension is deducted at both SISIP and Veterans Affairs Canada. So the fact that you get $1 from the Canadian Forces Superannuation Act, which is a pension, by the way, it is not income, it is property. So when you get your dollar from the Canadian Forces Superannuation Act pension, there is the serious risk that you will lose $2 if you were injured in service. Because SISIP pays even if you weren't injured in service, so there's no guarantee of you getting you the income replacement benefit. But if you were getting injured in service, you would probably get both, and both departments would take it into account. So you get $1 Canadian Forces pension, you lose $1 off of SISIP. You get $1 Canadian Forces pension, you also lose $1 off of Veterans Affairs Canada's income replacement benefit. Then to add insult to injury, Veterans Affairs takes SISIP into account, the fuckers. Now, none of this is supported by public policy. None of this is supported by the law. National Defense Act, Section 39.3 says that a non-public property is inalienable. Now that means it cannot be touched by a creditor. So, Newfoundland also has a Newfoundland Insurance Act, Section 29, for example, in my province, and they say that insurance is not touchable by a creditor. Now, a creditor is somebody who goes to court, takes the trouble to get a judge to rule in their favor. After the judge rules in their favor, they have an enforceable judgment that they can then go collect on. If you're watching the news in the United States, you have Donald Trump, the former president, and he has a $460 million judgment that he has appealed and he has to put a bond up against. But the government of New York, the state of New York, can seize and sell his property because they have registered a judgment against him, and therefore they can collect on it. In every province of Canada, there are statutory laws that spell out exactly what the procedure is in order to collect the debt legally. Clawbacks ignore that provincial collection law. The government wants to be above the law. That isn't fair. You are not supposed to be above the law. Now, getting back to the case and some of the things that I was noticing, I'm not going to go through it in a fine, like a fine tooth comb, or whatever that saying is. But basically, they're saying that there was $100 million that the law firm spent about 5,000 hours working on it, and that worked out to the legal fees because they had a sliding scale of legal fees. They had 30% if they got less than $10 million, 20% if it was between $10 and $20 million in damages, and 15% if they got $20 million or more. So because the settlement was $100 million, they got 15% plus their legal fees. So it came out to about $3,000 an hour, $70 million. But the thing is that they called it a human rights violation. Now, Section 15.1 of the Charter is the human rights violation that they're talking about. And this is the case I'm looking at is about the settlement details. This wasn't a case that was tried by a judge. It was settled at a court, and the settlement, at least this is the way I read it, and the settlement is published for us to read about what they agreed upon. Now, here's my understanding of a charter complaint. Under Section 24B of the Charter of Rights and Freedoms, you have the right to take an infringement of your charter rights to a court of law and seek damages. Now, damages in a charter case are very minimal, almost nominal. Oftentimes, I've seen cases where you barely get the maximum of like $25,000. But here the government set a pretty high standard, $100 million. And the breach of the charter that they did was they breached Section 15.1 of the Charter of Rights and Freedoms, which is that they put a legal burden in or under the law on the disabled. I agree that it's a breach of the charter. It's just that they should have also probably had a separate cause of action, it's called. So you have the charter breach, which is you breach the charter, that's a cause of action. Then you have a breach of the statutory law, which is possibly negligence under a tort. So you would say that they applied Section 22A of the Veterans Wellbeing Act regulations, which are subordinate law to the Veterans Wellbeing Act. But Pension Act Section 30 forbid them from taking that money into account. Financial Administration Act Section 67 also forbids the assignment of a crown debt. So with those two laws disagreeing with the Veterans Wellbeing Act regulations, you have a what's called interjurisdictional immunity problem. So they've created a problem where two laws oppose each other. Now normally this is when the provinces and the feds do a law against each other's laws, which is probably why it's called interjurisdictional immunity. But in this case, it's the federal government passed two laws that disagree with each other, which is downright incompetent. Well, I'm sure some people make mistakes. Like everybody makes mistakes, nobody's perfect. But the government has a lot of lawyers in its employ, and they help write the immunity laws. So when they write, or if they were consulted, and I'm not sure if they really were consulted, that I think they just assumed that because the clawbacks in SISIP has been operating without them getting slapped on the wrist for decades, I think they assumed that the Veterans Wellbeing Act regulation, Section 22, was okay. Well, the government repealed Section 22A after the Manouche case was lost in court. Now, the smart thing that the government should have done back then, as far as I'm concerned anyway, was they should have said, listen, boys, the new Veterans Charter came into effect in 2006. We've been clawing back the pension since 2006. So in accordance with the precedent set in the Manouche Federal Court 2012 case, we are going to refund the Pension Act pension clawback to the veterans who suffered this amount being deducted from their earnings loss benefit. Bob's your uncle. Instead of that, they tried to appease people by giving them 3 months without retroactive. And then they're playing a game of chicken with the veterans, hoping that they won't sue. Because they did give them some retro. They just didn't give them as much recognition, as much respect as the Manouche class. So again, you can tell I'm not very happy with these kind of decisions because it gives a very poor example of how our government operates. Sometimes I'm ashamed to be a Canadian with how Canadians treat the disabled Canadians, and with respect to disabled veterans, that leaves me aghast sometimes. Well, a lot of times. So, let me see if I can find anything that jumps out at me. Well, see, here's the thing. As far as I'm concerned, this should have been a 99.99% chance of winning. And here they are talking about the plaintiff and the defendant submit that the settlement agreement is fair and reasonable, right? And then that they said they had litigation risk. Well, they didn't have very much risk, saying that Manouche won on the very same issue. Where was the risk? There was no risk. Absolutely zero risk of failing in this case. Now, caveat, here's what I suspect, because this is what the government said in its reasoning for giving 3 months retro. Well, the Veterans Wellbeing Act regulations are laws that we pass. And they're legal and enforceable until we repeal them. So because they were legal as we made them and they aren't repealed, so then we didn't do anything wrong, and therefore, we got no reason to pay you back more than the 29th of May, 2012. Like, the law was in place, we didn't repeal it, so there's nothing to see here. Move on. I'm sorry, it doesn't work that way, you son of a bitches. It's not supposed to work that way. Unfortunately, all of the cases that I've seen about veterans are disgusting. Is it this fucking disgusting? There was a case in BC. They called it the Equitas case. And the government shouldn't have won. It didn't have any grounds to win. But they won. The Manouche case, which he won, but I suspect it was a trap. They knew they'd had to fix it after the Canadian Forces Ombudsman report in 2003. So they changed the law to get in the Pension Act to minimize their damages for breaching the law. And then they flipped it around. Like, under the old system, SISIP took the Pension Act into account, and under the new system, the Pension Act replacement would take SISIP into account. Well, I'm sorry, but you can't do that. You see, what everybody's missing in the SISIP class action is that the payment that was being made under the Pension Act was more important. It's the equivalent of damages in a lawsuit in tort. The right to sue was exchanged to get that pension, so therefore, a payment of insurance that has nothing to do with an event that causes injury cannot take into account something that is indemnifying you for an injury. Want proof? The Ontario Workers' Compensation Act says that no one can touch a workers' compensation payment. Now, a workers' compensation payment is the equivalent to the Pension Act pension and equivalent to the income replacement benefit, arguably. Well, you'd have to say is equivalent to the suite of benefits, not just the income replacement benefit. So, now here's something. Even though I only skimmed this case so far, the government doesn't seem to realize that it has set a precedent. Okay, what was the precedent? The precedent is that clawbacks violate human rights. So, we can sue them on a separate cause of action. Remember, you can have multiple causes of action. If you want to, you can label a whole bunch of different things, and you can seek damages. But unless you have what's called an independent cause of action, you're only going to get the same damages, no matter how many types of damages you have. But charter damages are different than tort damages, which are different than contract damages. So that's three different causes of action right there. So you could sue someone, get damages for their breach of your human rights under the charter, and get, in addition to that, compensatory damages under the equivalent of a lawsuit and tort when they replaced the lawsuit and tort because you exchanged the right to that. So basically all the new Veterans Charter stuff or the Pension Act. And you can get your SISIP long-term disability in addition to those things because it's a non-indemnity and contributory payment, and that has always been allowed in addition to an indemnity payment based on the insurance exception rule or the insurance and charity exception rule. So there are two things that are allowed to be received in addition to tort damages. One is insurance. Non-indemnity and contributory insurance is not to be clawed back from a damage award. Now the other one is charity. So if someone gives you a payment that's a gift, during the time, say you're waiting to get your damages, they can't say at the court, hey, we're going to take that gift that someone gave you into account, because the public policy is that it would reduce the chance of people being good to their neighbors. So therefore, it's good public policy that they treat it like insurance. Now, pensions have been brought into that two exceptions because pensions and insurance are roughly the same thing. So if you get, say, a disablement superannuation act type pension, it's non-indemnity and contributory because you contributed to it. Pensions are property, so therefore the payment you get is not compensating you for any damages. It's paying you the money that you already own. It's your money. They're holding it on in a trust, and they give it back to you, and they dole it out monthly, but it's your money. So therefore, if you're getting paid damages, they can't take that into account. And that is why the Pension Act pension never took the Canadian Forces pension or the Canada Pension Plan into account. Not because they had some, we're going to treat these veterans special and allow them to get these monies without clawback, but because of the legal nature of the money, you wouldn't be allowed to claw it back. You're just not allowed to. It's not allowed in the common law. Now, that's enough about that right now, because although I just thought a number of 15,000 veterans being involved in the Toth case, I'll look it up a bit later and see if that's the really, the number, because that's even more than the Manoj case. And the other thing I'm going to talk briefly about is about the call I had from CRA about my taxes not being filed. Now, I used to be really diligent about filing my taxes. After all, I was a payroll tax collector for many years for Canada Revenue Agency, so I took my duty seriously. So I filed them on time. I never lied on them. Now, I've been telling them about so many problems over the last decade or so, and they have been ignoring me, that I have been saying to myself, if they're not going to listen to me, fuck them. Now, it's not really that big of a deal as far as I'm concerned, because they get the fake T4A forms filed from Sun Life, for example, and they used to get one from Manulife, and this is what I told the agent from CRA. Listen, you guys, look at my file. I said, do you see T4A forms on my file since 2009 from Sun Life? Yes, he said. Those are fake. I said, after the Dennis Manoj class action, which I wasn't part of, but it turned out that the Manulife policy 901-102 was in fact underwritten by the Government of Canada. Well, I can infer that the Sun Life policy is exactly the same. But in the case of Manulife, I know it is the same. Now, when they had a settlement affidavits, when they had the settlement after the case was over, the Government of Canada agreed in writing that they would, for example, file all tax forms the defendant would through Manulife. Now that means the actual form came from the Government of Canada, but they passed it to Manulife and they filed it with you, with CRA. That means they're lying. Now, I don't want anything to do with people who are lying to the government and to me on my file. Secondly, I said, because I used to be a payroll tax collector, I happen to have been researching all this stuff for many years, and I know of the Université de Laval Federal Court of Appeal 2002 case and the National Bank of Canada Federal Court of Appeal 2003 case, and in both of those cases, Canada Revenue Agency took these two employers to court about their employment insurance premiums, and they argued successfully to the court that because the source of the payment was the employer, then employment insurance premiums were due to be paid. But the lesson here is CRA did not just accept what was filed, they looked deeper, and they said that we know we have a payment listed from Manulife, but in fact the employer is really the one who made the payment. The same thing applies. Now, I told them, at least I think I did, I said I suspect they're trying to abuse the rule of law. They passed policies and they require non-government long-term disability insurances that are self-insured to take EI and CPP out. EI is taken out at 140% of whatever's taken out for the employee. The employer has to put 140% of it with it. So if the employer took $10 out of my check, they'd had to put 14 with it, and they'd had to remit 24 to CRA, who would then remit it to Canada, EI. For the CPP, it's 100%. So if they took $10 out of my check, they'd put $10 of their own money with it, and $20 would be sent to Canada Revenue Agency first, and then on to the Canada Pension Plan. So I said there's a very clear financial motive for them to lie on their fucking T4A forms. Now, another thing is privacy, I said. Canada introduced a quasi-constitutional act concerning privacy in 1982. And in 1982, they decided that the public needed to be protected from the government. And the government had to have a legitimate need for information. The government had to collect the information directly from the person when they could. And the information had to be accurate. Now, if you're filing a T4A form from me through Manulife, the government of Canada, is, then I can say with 100% certainty that is not factually accurate. So I presume the Income Tax Act is subject to the Quasi-Constitutional Privacy Act, and I assume that you need personal information to administer the Income Tax Act program. But that does not allow you to file false T4A forms and associate my name with it. No, you don't. So now where do we go with this kind of stuff? I've been telling them about this for years. So what I plan to do, and I've started this, is to write a letter. I know I'm beating my head against the wall. I know it's probably not going to do much good. I'm going to do it for the public, for social media purposes, rather than expecting the government to all of a sudden say, "You're right, Matt." I'm going to basically call them out again. I'm going to attempt to go to my member of parliament, and I'm going to attempt to get them to sign off that they have received this information. I don't expect them to agree with me. I'll give you another example about Income Tax Act Section 61F, which is one of my pet peeves as a law. Now, using the Toth Federal Court 2019 case, we know that damages are available for breaches of human rights. Charter Section 15.1 states that no law will be made that puts a legal burden in or under the law on the disabled. Well, Income Tax Act Section 61F charges tax on a person who is disabled and unable to participate in the labor force. Now, some people might say, well, this is fair, everybody's got to pay taxes. Except when you think about the purpose of Income Tax Act Section 61F is to subsidize the healthy taxpayers by having disabled people pay taxes so the other people's taxes are lower. Sounds like discrimination based on disability to me. So, with that in mind, charter damages are available, I'm certain, under the Income Tax Act, under the Charter Rights and Freedom Section 15.1, because Income Tax Act Section 61F violates our human rights. Now, I don't know if tort damages are available, but my other point, and I'm going to stop after this point, I don't want to be on too long, right? Okay, there are two statutory conditions attached to a long-term disability insurance payment becoming taxable. First of all, I'll give you a bit of background. Canada has Section 5 of the Income Tax Act, which is about employment contracts and stuff, and then Section 6 has fringe benefits of the contract of employment. So they put Section 61F in there to deem a long-term disability insurance payment to be part of the employment contract. Now the problem is, well, for the Canadian Forces members, so there is no employment contract that they can deem SISIP to be part of. Okay? There isn't. Now for the public servants, the argument doesn't fly because unions negotiate a collective agreement with the government, and therefore Section 61F might apply. But here's where it fails. The two conditions are the payment must be periodic. Now that's a technicality. But if it's not periodic, if you get a lump sum, it just isn't taxable, period. End of story. Now the second statutory condition is that the employer must make a payment towards the premium out of its own funds. Now, here's the deal. Here's the problem. Canada's Income Tax Act was changed in 1971. And they said they put this law in place. It wasn't in place before. So that begs the question, why did they have to change it in 1971? But in 1970, there was a case in England called Perry versus Cleaver. And in that case, the people that hurt the guy said that they ought to be able to take the disablement pension into account because he didn't pay for it. So the judges in that case said, he didn't put cash up for his pension after he became disabled, but surely his weekly service has value, and therefore he paid for his pension, so you cannot take it into account. Now, the lesson here is that before they brought that law in to say that the employer has to make a payment out of its own funds, well, they should have known better that there's no such thing as a payment out of its own funds. Now, to back up what I'm talking about, I found in the Vote 20 information, which is about public service insurance. So every year the government has to vote on money to fund the government. So Vote 20 is the vote for public service insurance. Now, when I was looking up the description of this not long ago, I had it years ago, but I read it more closely recently, they said that this money is for payments to insurance plans made in respect of public service. Now, after all these legal readings that I'm doing and my work with CRA, in respect to is a very important connection between two subjects. So if you get paid in respect to service, you're getting income, and you got to pay taxes on it. If you're getting a payment towards an insurance plan in respect of your service, it's income in respect to your service. So it's not being made over and above your salary. It's the payment as the government's legal obligation to remunerate the person who gave the service to the public. So this is a groundbreaking, earth-shattering, light bulb going off over my head, because it totally shoots down the idea that the government puts any money up out of its own pocket. See? Now, in Section 14 of Paragraph 14 of Income Tax Bulletin 428, now a little bit of background. Income Tax Bulletin 428 is about wage loss replacement plans, which is CRA's tax speak for long-term disability plans. So, in paragraph 14, it says, for benefits received by an employee under a wage loss replacement plan to be subject to tax in his hands under paragraph 61F of the Income Tax Act, the plan must be one to which the employer has made a contribution of its own funds. An employer does not make such a contribution to the plan if he merely deducts an amount from an employee's gross salary or wages and remits the amount on the employee's behalf to the insurer. Now, that could be exactly how to describe what they do. But I say could because I don't know that they actually send the money to Manually for Sun Life. I suspect they don't. Not in relation to buying an insurance policy. They probably send the money there to cover the people that are approved, but that's not the same as premiums in anticipation of. Premiums had to be paid before a claim, an event, not after. So, the thing is, I suspect the government merely funds the program and not puts in premiums. But if it is looked at premiums, there's a couple of things that might come to mind. The first one that comes to mind in my mind is does the payment have to be made to a third party to underwrite the policy? So in the case of the Service Income Support Insurance Plan, we know that the Government of Canada, the Crown, underwrites the program. So the payment that is deducted under law, Queen's Regulation and Orders 208.53, they deduct an amount from your pay. Now, if they deduct that amount from your pay, who is to say that's not enough? Like, they claim that they put in the corresponding amount and then send it to the insurer to buy an insurance policy. Well, if that's the case, prove it. Don't just tell me something. That's a story. Give me evidence. Show me some kind of forensic audit. Show me something certified that this is what happens, and I will believe you. As an example, even though I meant shut up and turn this off, I requested a copy of my entire file under the Privacy Act from CRA. And when it came up that I was appealing my taxes on SISIP and Sun Life, this thing about the employer making a payment out of its own funds came up. And to prove that they were right, they said, we looked up Treasury Board's site on insurance, and it says that Treasury Board pays 85% of the premium, and he pays 15%, so therefore the government paid, his employer paid 85%, so therefore it has to be taxed. That's not proof. That's something on the internet, on a website created by Treasury Board, who, as the government, wants this to be taxed. Now, another point, and this will be my point, last point I promise, is that if you wanted to have what's called an employee payout plan declared, CRA says that they're the one who decides. And the way they phrased it made it seem like the employer would want to help their employees out and would give them a break and claim it even if it was false. That's the way I read it. Now, on the flip side of that, I work for CRA. CRA is part of the Crown. The Crown insures Sun Life and SISIP. Now, if I want to have them look at this and decide if these are employee payout programs, plans, which would then be tax-free, they will be the same as personal taxes bought by yourself, which is what they are. CRA, which is the one who pays the insurance through the Crown, would decide on if it would be the judge on its own case. Now that's against the law, against the rules. Natural or fundamental justice has three things that are required: notice, a hearing, and the hearing has to be before an independent judge. Now, if we want to figure out if SISIP, Sun Life, and Great West Life and the Public Service Management Insurance Plan are employee payout plans instead of what the government wants it to be seen as, is the government's giving you some kind of a perk, then somebody other than CRA has to adjudicate the file, because they have an unavoidable conflict of interest. It's no good to tell them that, because they think that they don't. But again, I keep talking even though I want to shut up. Denial is not a defense. Okay, just because you say you didn't do it or it's not breaking the law doesn't mean that it's really okay. Okay, you know, what you need is somebody to look at the facts and make a judgment. Now, the Canada Revenue Agency employee that I spoke to years ago, I spoke to her for 3 hours. Every point I said she agreed with. At the end of our call, I expected her to approve my appeal and take off the taxes on my long-term disability. Instead of that, she said, well, I have to apply the law as her reasoning. Well, that's an arbitrary judgment, and people who work for the government are supposed to act judicially. They are supposed to take in facts and then make an impartial judgment. By saying that I have to apply the law after she agreed with everything I said, she created what's called in psychological terms cognitive dissonance. I couldn't believe my ears. She had every opportunity in the world after I made a point to say, oh, you're mistaken there. You're not seeing that from the right viewpoint. No, you're wrong, Matt. If she had said any of them things, I wouldn't have been surprised at being told no at the end of our conversation. But by saying she agreed with everything I said along the way, she set me up to anticipate success. Anyway, I'll see you next week, and thanks for watching.